5 days before trial, the team had to make a call. Put the defense witnesses on the stand live or play their deposition clips. Instinct tells you, put them on live. But the focus group data told us to play the clips. And they went with the clips. Today, I want to talk about why and about the question that decision was really answering, because the call really wasn't about live witness versus Depo clips. The call was about how do we want the jury's first impression of these witnesses to be formed. Welcome to Trial Lawyer Prep. I'm your host, Elizabeth Larrick, and this show is where we get into behind the scenes about trying cases, the strategy, the prep, and the decisions that decide outcomes before anyone walks in the courtroom. Today's episode is about one of those decisions, specifically adverse witness decisions that you make in trial about primacy. And I'm going to show you what that means using a case where a trial team made the call and won big. So let's dive in. Every trial lawyer faces this decision. In almost every case, do we call them live or do we use the deposition clips? And this could be your witnesses and it could be their witnesses. I mean, if you're doing a med mal, it could be the defense doctor. If you're doing trucking, it could be the corporate rep. Employment, it could be the HR director. Really, any kind of case, any kind of practice area, you're going to have to make this call about live witness versus clips. And instinct tells us, training tells us, do it live. Live is better. Video puts people to sleep. Live is more persuasive. Live is much more catchy for cross-exam. However, I want us to question that decision because what we're going to walk through today in this episode really boils this down to a primacy question, meaning that first impression. Now, we talk a little bit about primacy on this podcast. We think through our opening statements. And what I want us to look at here in this situation is how you use primacy for that first impression of a defense witness. Because we know through brain science that that's what primacy is. That first impression is sticky. It's hard to get away from once it's set. And if you can take advantage of that in trial, why wouldn't you? So we're going to talk about how two different lawyers use this in two different ways. My first example is an employment case that I worked on where the lawyer had been working through depositions, had a very clear deposition of the HR witness. But through focus groups had learned that the key wasn't necessarily the witness, but rather the documents, the HR documents. And so everything in her told her she needed to get the documents first. But when it came time for trial, the defense game started about where the witness was. They knew that she could just play Depo clips, and that's what they kept telling her, but she fought for it and made sure that witness came live because she knew the documents needed to come first, but also they needed to be delivered by somebody live to watch and see how those reactions were to the information. And it worked out very well for her. But I want to talk about another case where we made the opposite decision. This was an eminent domain case. A pipeline company came in and took a piece of land from a larger ranch, and the fight was about how much. And in cases like these, it really kind of comes down to expert evaluation. And the team, again, skilled trial team, they'd been building this case for years. They weren't waiting for trial to get prepared. They even ran their own early focus groups before I got involved, kind of teasing out themes, testing facts, refining the story. But overall, they knew that this was probably something that was going to trial. The pipeline company evaluation was $25,000 and theirs was $12 million. Pretty large gap here. So what they decided to do is during depositions, always keep trial in mind. He knew he was going to be gathering information, but he also knew he needed to build in his case theme early, even before the defense saw anything coming. And then 5 months out from trial, he called me in. It was time to test and see if his work had paid off. 3 virtual focus groups, a 1 in-person mock trial, and the job was to test themes, test those experts, and test the deposition clips of the defense witnesses. And here's something important about how this work gets done. We really wanted to make sure we were being consistent with our work. So we used the same setup for every session, right? We used the same clips, the same questions to make sure we would be able to compare the data across. Because we don't want ego to creep in. We don't want guessing to creep in. If we had ran 4 different sessions on 4 different types of materials, we would have gotten 4 different results. We wouldn't have felt confident about going into trial. So we made for sure those specific testing pieces to be the same. And let me show you what some of this data told us. Again, the key thing here that we're talking about are adverse witness clips. So we tested credibility on a scale of 1 to 10. 1 is the lowest, 10 is the highest. We tested asking them, what questions would you want to know? And here is literally how some of the results came out. The corporate VP, his average was 1.5. No jurors in our in-person mock gave him above a 4. The other witnesses did not fare well either. I think the average was 3.75 on some of these. And this was consistent across all of our focus groups. Here are some of the questions that they wanted to know. What are you hiding? Why did the company send you when you obviously don't know anything about this? Why are you testifying in this case? You don't even seem to have any relevant information. Now, here's where I want my trial lawyers to take notice. The trial team's case theme was don't care, and they had been building it, but they didn't know whether it was apparent, and they were rewarded, right? All of our focus groups came back on their own, determining these people don't care about what's happening here, and those clips and those numbers solidify that. The company didn't even bother sending someone who knew anything about the case. The defense witnesses proved up the theme. So the data is clear, the feedback is clear, but that doesn't make those decisions easy when it comes time to trial. Again, coming in, and we know tradition tells us, call these witnesses live. It's going to be so much better. It's going to be way more persuasive. That cross-exam is going to land so much better. However, those clips also solidified that first impression that we knew could not be overcome. But there's always a risk that if you play a clip, that the other side gets to pull the witness up and ask them questions and kind of commandeer and take over. And what if those questions, right, take all the wind out of the sail from the clips? There's always that chance that they're going to do that. And so it was hard to make the decision in this case, but that's where my role came in to remind them how solid this information was from our focus groups, consistently telling us over and over again, terrible credibility. What are these people doing here? Why are they testifying? And so when it came down to make this decision, right, everybody sat down on the team and rewatched the clips to make sure. Are they clean clips? Are we getting exactly what we need? And then also ultimately deciding, okay, so it's always going to be a risk, but the data tells us it's good. And ultimately they did decide to play those clips. And here's what happened at trial. Those clips played, and those juror faces were clear. They were annoyed. They were even at some times, writing aggressively when it came to these clips. And they were short. Trust me, we did not trot them out for a long, 10, 15 minutes, very short things. But the annoyance was very clear, exactly what we'd seen from focus groups. And then it got even better because the defense actually called 1 or 2 of those witnesses live. And the jurors were visibly shaking their heads because they couldn't believe they brought them back. And then despite looking friendly, working hard and being, charming, it didn't make any difference. Didn't change the impression. It was already set and very obvious. As the witnesses gave their answer after answer that sounded contrived, they, again, just shook their heads. And it wasn't subtle, right? Everybody could see it. They were physically rejecting what they were hearing in real time as the opposing counsel was asking questions. So the clips did their job. The live appearance just confirmed what we knew. And the verdict, $7 million and change, about 280 times the pipeline's offer, way closer to our expert than theirs. And I'll tell you, primacy worked. The bet paid off. And here's something I want to name about how a case like this gets won. Once the focus group data was in, my job sharpened. My daily mantra during trial to the team was very simple. Remember where we started this case. Remind the juries of it. Every single witness, think about that primacy. Where are you starting? If it's direct, if it's cross. Every choice we made should be reinforcing what we knew was so clear from our focus groups. And even when we got to closing argument, and there's all these extra layers, these defense games that are being thrown out there, stay true to what you know. Stay true to what has been told. And it worked, right? And the defense was losing, and they didn't even know it. So this clips versus live decision is something that we have to make in almost every trial. And I will tell you, you need to test it to see what the risk is. But always be thinking about these as a primacy question. How can you shape that first impression? And what does it need to be? Focus groups will help you with that. So the skill isn't memorizing the right answer. It's rather testing it to figure it out, but also understanding that you can plant the seeds early on in the case and come back and use them to your advantage or not. You may decide, you know what, it's going to be better life. Or you may decide, poof, these are so good, I got to play them. So make sure you know what the juror's first impression is and how you need to shape it. If you've got a trial coming up and a decision you're wrestling with, you want to test it out, you want to find the first impression, then book a free call with me with the link in the show notes. Until next time, keep prepping for success.